Hey guys, in the previous two videos I discussed the topic of the duty of care. So today we are going to talk about breach of the duty of care. Before the plaintiff, the person suing, can prove that the duty of care owed to him by the defendant has been breached, the plaintiff will first have to establish the standard of care that would be that of a reasonable person under the same circumstances. This is an objective test, under which the defendant is judged not by his own characteristics and attributes, but by the nature of the task he is performing and the circumstances in which he is performing it. This was set out in the case of BNJ and SMRT trains and another. Therefore, the plaintiff must prove that the defendant acted below the standards of a reasonable person, judging not by his own characteristics, but the nature of the task he is performing and the circumstances under which he is performing it. Whether there has been a breach of a duty of care is to be determined according to the specific circumstances of the case. This is a factual issue and not a legal issue. Why is it factual? Because it depends on the specific circumstances of the case. So if a judge in one case decides that a motorist breached his duty of care by failing to slow down or stop at the traffic junction, doesn't mean that it's a legal principle for future cases that the standard of care of motorists is the standard of care expected of motorists is to slow or stop at traffic junctions. The standard of care is not normally lowered to take into account the defendant's inexperience. Otherwise, this would be unfair to those who he injures. Okay, this was set down in the case of Nettleship and Western. So for the same reason, an amateur, a novice, is judged according to the objective standards of acceptability for the task in which he is engaged, not according to his personal level of expertise. So for example, a crane operator, he operates a crane and for some reason he doesn't operate the crane properly and he hits someone. He causes the crane, which is carrying some kind of brick concrete, to hit someone. Even though he is an amateur, a novice, or an inexperienced person, the standard of care will not be lowered by taking into account the fact that he has no experience. He will be held to the ordinary standard of care of a crane operator. The Singapore High Court in Yeo Pek Hock and Pai Lili held that the basic test for establishing causation is the but-for test, under which the defendant will be held liable only if the claimant's damage would not have occurred but for his negligence. Or looking at another way, the defendant will not be liable if the damage caused to the plaintiff would or could have happened anyway, regardless of the defendant's negligence. So the only time the plaintiff would not have to prove exactly what act or omission the defendant caused the accident is when the accident was obviously due to the defendant's negligence. This is called the doctrine of res ipsa loquitur, which is Latin for the facts speak for itself. For the doctrine of res ipsa loquitur to apply, a few factors must be taken into consideration. The means by which the damage was caused must have been within the defendant's sole control. Number 2, the accident would not have happened if care had been taken. Number 3, there was no other explanation for the accident other than the negligence of the defendant, and the defendant does not offer any alternative explanation. If res ipsa loquitur is successful, the plaintiff does not have to prove that the defendant was negligent, because such negligence will be presumed to have occurred. So thanks for watching this video on breach of duty of care. Stay tuned for the rest of the videos.